नमस्कार करती हूँ. I extend a warm welcome to all the participants and organizers of this program today. And I extend a special welcome to Ms. Susheela Sarathi, who is our guest faculty today. Today is the 5th day of summer school of Nivaaran Mediators of Supreme Court of India. This program was started on 22nd July with the opening ceremony. And the first lecture on 24th July, the topic was historical perspective of dispute resolution. And on 24th July, the topic was an overview of conflict and styles of conflict. Third day on 25th July, the topic was definition and process of mediation. Yesterday on 4th day, the topic was communication skills needed for a mediator. And today is the 5th day of Summer School of Nivaaran. This is being organized in collaboration with Singapore International Mediation Center and Commonwealth Lawyers Association. As you all know, that Nivaaran is a team of mediators from Supreme Court with the aim and purpose of promoting mediation and for enhancement of skill and knowledge of mediators. The first program of Nivaaran School of Mediators was organized in January 2020. However, before the COVID-19 pandemic had struck the whole world. However, thereafter, with the initiative of organizers and with initiative of all the mediators, the program has been organized virtually. And this is the 4th year in continuation with huge success that the program is being organized. Friends, all you know that India has a very rich cultural heritage. Mediation through negotiation to solve all conflicts and issues is being practiced in India since Vedic ages. And our forefathers, instead of taking one-sided decision on any issue of conflict, always believed to deliberate on every aspect of any issue. All the parties used to put forward their viewpoint and listen to others, and if required, they will seek help of facilitator, mediator, and negotiator, with an underlying purpose to find out the solution to the problem. In India, Dev Rishi Narad was the first one who started practice of samvad, that is negotiation. All our Mahakavyas, whether it be Vedas, Upanishads, Shrutis, and Smritis, are based on dialogue and not monologue. Purpose of dialogue is Nivaaran, that is resolving the disputes in a manner which is in interest of parties and for public good. If the practice of dialogue and negotiation is not adopted, there is bound to be a communication gap and the problem may increase manyfold. Our courts and legal fraternity over a period of time realized that instead of contesting cases in courts for decades, mediation and negotiation can solve the human issues, and the result of mediation are definitely encouraging. In the present day, mediation in fact revived old age Indian practice of samvad. Even when the emotions run high and parties, instead of taking recourse to the police or approaching courts of law, think with a cool mind and turn to dialogue and negotiation, then the results are definitely positive. Mediation can do wonders in uniting hearts, families, and nations. Negotiation in any form of direct or indirect communication, whether parties who have been opposing interests discuss the form of any joint action which they might take to manage and ultimately resolve the disputes between them. Negotiation is voluntary. It can be bilateral or multilateral. It is non-adjudicative, informal, confidential, and flexible. In fact, negotiation is probably the most practical form of dispute resolution, as it involves only those parties and their representatives who are interested in the matter. Negotiation is effective way of solving any type of conflict. Negotiation occurs in business, non-profit organizations, government branches, among nations, and in personal situations. such as marriage, divorce, and everyday life. People settle their differences by compromising and reaching an agreement by negotiating. A negotiator should always plan strategies before meeting for negotiation. Prior preparation is very important because it helps in assessment of one's goals and helps in anticipating the other party's approach. The advocates as mediators have a great responsibility to render to the society to make world a better place. It involves brain as well as heart. Both and mediation can be a medium of happiness for parties. Friends, today there will be a 20-minute session, 20-minute question and answer session after Madam Susheela has given her views. And participant can post the questions on the chat box, or they can ask the questions by raising their hands direct. So now may I have the privilege to introduce Susheela Madam to the participants. Today, she is the esteemed speaker. Susheela Sarathi Madam, which has a very meaningful name. And in case of Madam, it is Yatha Nam Tatho Guna. That is, she possesses the same qualities which her name denotes. Sarathi is the one who drives you to your destination. Indian culture has a deep meaning for the word Sarathi. Sarathi is friend, philosopher, and guide. Whenever one is confused, not able to take a right decision, then in such a situation, the Sarathi guides you. And the Sarathi drives you to your destination and leads you to a right path. Lord Krishna was Sarathi of brave Arjun when in battlefield of Kurukshetra, Arjun dropped his weapons after seeing his family member as his opponents. Lord Krishna cleared his doubts and imparted knowledge to him, now popularly known as Srimad Bhagavad Gita. Today, Susheela Madam would enlighten and impart knowledge to all the participants on this 5th day of summer school on negotiation, definition, soft, hard, and principled negotiation, negotiation skills needed for a mediator as a facilitator of negotiation, conclusions and agreements in mediation. As you all know, Shrimati Susheela is a designated senior counsel practicing in High Court of Karnataka for last 37 years. She has done her master's in sociology, postgraduate diploma in industrial relations and personal management from Catholic University, postgraduate diploma in ADR from ICADR. She is a trained mediator from ISDLS USA International, commercial mediator, trained from Strauss Institute of Pepperdine University, USA. She is trained in commercial mediation from ADR ODR UK London. She is a senior mediator and trainer, recognized by Mediation and Conciliation Project Committees, MCPC of Supreme Court of India. She is a master trainer of Bangalore Mediation Center. She has trained many advocates, judges of higher judiciary and many professionals in mediation. She is also one of the members of committee constituted by the MCPC of Supreme Court of India in preparing draft legislation of mediation. She has authored many books, which includes 3 books on mediation, 1 book she's written on Hindu Marriage Act, and a book on substantial question of law published during last year has gained popularity. She appears regularly on small screen in discussions related to social and legal issues. Susheela Madam is also an avid blogger, and she has started her blog in December 2019, namely Totem, that is Training of Trainers in Mediation. The blog is very famous and is heavily subscribed. And Madam is multilingual. She is proficient in Kannada, English, Hindi, Urdu, Tamil, and Telugu languages. Now may I request Susheela Madam to take over the floor. Over to you, Madam.
Thank you, Sunita ji. It was too generous, rather, the introduction.
Thank you.
I should live up to your expectations, that's all.
You would definitely, and ma'am, you are living up to our expectations on this.
Thank you. Thank you so much. My sincere thanks to Nivaaran, Commonwealth Lawyers Association, and also SIMC, Singapore International Mediation Center. It's always a pleasure to be associated with Nivaaran. Lots of learning will be there. This time I'm more excited because CLA and SIMC are also part of this entire program. In fact, in the last 5 days, we have gone through several sessions, extremely interesting, and we had many things to learn. Thanks to Nivaaran once again for the same. However, considering today's topic, the brochure itself divides it into 5 parts: negotiation definition, soft, hard, and principled negotiation, negotiation skills required by a mediator, and then conclusions and agreements. The last 2 parts, conclusions and mediation, agreements, I will confine myself only as far as negotiation is concerned, nothing beyond that. That's how I have structured the whole program. Now, how do we define negotiation? There are a number of definitions, but I believe in understanding the concepts at the fundamental level. A wonderful definition which I always keep with me about negotiation is this: getting what you want at an acceptable price. Simple definition. What is negotiation? Getting what you want at an acceptable price. One thing that we need to understand as mediators or negotiators is that getting what you want also includes avoiding what we do not want to get. The second part plays a vital role. Many a time, what happens is we are always in a fix. Why this person is not accepting what is being given to him? It's a fair offer, but that element that's being offered to him also has got with it many things which he does not want to accept. So getting what you want at an acceptable price also includes to avoid what you do not want to get. This we need to keep in mind whenever we are assisting parties in negotiation. Mediation is considered as assisted negotiation. We are facilitators. What is a big deal here? When we are assisting the parties in negotiation, it should not just be a deal. It should be a good deal for both of them. That's one aspect that we need to understand. I always question myself, had I not been here in the picture at all, would they have got a better deal or would they have not got this deal also? These are the 2 questions that I always put to myself. Now, why do they need our assistance is one thing that we have to question ourselves. In order to negotiate with another person, there should be an element of trust, or more important than this, there should not be an element of distrust. What happens here is how to establish trust with someone whom you do not trust. Parties are always in a fix. Disputants are always in a fix because they don't trust the other party. In such circumstances, they need our assistance. We are the mediators who will assist them in negotiation. Another thing is, some persons for various reasons we may not like. Particularly disputants may not like each other. How do you force me to negotiate with a person whom I don't like, whom I don't want to see at all? That's where the assisted negotiation is required. You require a person who makes you to negotiate with a person, notwithstanding the fact that as on that day of initiation of mediation, you don't like him or you don't trust him. These are the two factors that we need to keep in mind. There is yet another factor. You love a person so much and you do not want to negotiate anything about him or with him. In child custody matters, we come across such situations. Or in some cases where they have to give some, they are expecting some give and take from their own siblings, such situations come. So there are some three situations. One is the trust issues there. One is where we don't like our we do not like the other person. The third situation is a situation where we love the other person too much. In these three situations, probably a mediator's assistance or a negotiator's assistance will be required. Having said this, when I said getting what you want at an acceptable price is negotiation, I remember a cartoon where two dogs were so well dressed. Those two dogs are in conversation with one another. One dog says to another, "It is not enough. It is not enough if dogs win. Cats should lose too." Look at this. Cats should lose too. So some people in negotiation, they just do not want to win. They want the other person to lose. Under such circumstances also, they may approach us. Probably those situations may be situations where mediators' assistance, if you can bring them out of that zone, probably we can achieve something. Otherwise, there's a situation where the matter will have to be without recording anything. I request this august audience to consider one aspect. When we say negotiation is getting what you want at an acceptable price, what is acceptable price? What is acceptable price will always depend upon time, place, and situation in which the parties are placed. I always give this example. This sari, I bought it for 6,000 rupees yesterday morning at 11 a.m. He quoted 8,000 rupees and we agreed, we bargained, and the deal was fixed at 6,000 rupees. Today, I see my junior colleague bringing the very same sari. I asked her, "What is the price you have paid?" She says, "I paid 4,000 rupees. What is it?" And she said, "I bought it when he was closing the shop." Morning 11 a.m., that was an acceptable price between 6,000 was an acceptable price between me and the shopkeeper. Evening at 9 p.m., when he was closing the shop, that was an acceptable price between the shopkeeper and my colleague. So what is an acceptable price must be left to the wisdom of the parties, and we as mediators are persons assisting in negotiation, or negotiators should not think too much about it. This is one of the principles behind assisting in negotiation. Now, in order to be good facilitators, we have two roles. One is we assist in negotiation. Second is we facilitate negotiation. How do you assist in negotiation is in the decision-making process. There's a lot of difference between decision-making and decision-taking. Decision-making is a process. Decision-taking is an act. Mediators will not have any say in the second scenario. Decision-taking is left to the domain of the participants only. We respect parties' autonomy or parties' right of self-determination. They can take something or they can leave something and walk away. But as far as decision-making is concerned, we have to give our assistance. We facilitate the process in such a way that the parties are empowered to take decision. There your facilitation comes. Here your assistance comes. Look at the difference. Your assistance is in the process of decision making. Facilitation is to enable the parties to take a decision. This difference, slight difference, you may have to kindly keep in. How do we assist is one aspect. Before that, we have to know when our role as persons required to assist is expected. There are 3 stages as far as negotiation is concerned. One is a pre-negotiation stage, and another is in negotiation stage, and the last one is post-negotiation stage. In all the 3 stages, we can't shirk away from our responsibilities. We should know, identify clearly what my role is in the pre-negotiation stage. There has to be clarity. As far as pre-negotiation stage is concerned, I always insist that the mediators will have to give quality time to the participants to vent out their emotions. Give them time in abundance. Let them tell whatever they want to tell. Once they tell everything, once they vent out their emotions, they are clean. Only then reasoning will work. Unless emotions are addressed, reasoning will not work. In the decision-making process, it is the emotions that start speaking. When emotions start intervening, we are nowhere. We are back and forth. There will be only movements, but there will be no progress in our mediation. That difference we have to understand. If you have not spent quality time in pre-negotiation stage, probably you will be a failure in negotiation process, or what you have failed to achieve during the pre-negotiation stage may pop up, causing you so much of trouble in the post-negotiation stage also. That's where we have to be very careful. Why I am speaking more about negotiation is, emotions is, in pre-negotiation stage, our duty is to understand what the party is going through and what will come in the way of party taking a decision. At the emotional level, if we take a decision in any walk of our lives, we may fail. But if the intellect has to work, then emotions should take a back seat. Only when emotions are addressed or emotions are allowed to be vented out, then what happens is reasoning will come. Reasoning can start functioning only when with the help of intellect. Intellect helps us to understand what we really want and what we really do not want. It helps us in the proper decision-making process. So in order to go from the emotional level to the level of intellect, you have to spend a quality time. If you don't spend quality time, probably the emotions will overtake. This one aspect you have to understand. Now coming to the second part of the today's topics that are given to us, hard, soft, and then principled negotiation is what is given as a subtopic. In the pre-negotiation stage, it is the duty of every negotiator or a mediator who is trying to assist the parties in negotiation to understand the style of negotiation the parties are adopting. There are 3 types generally considered as styles of negotiation. That's one is hard negotiation, competitive. Next one is soft negotiation. Then principled negotiation, which generally encourages us to look at collaborative or integrative bargaining as one of its ingredients. Now, when we say soft negotiation style or hard negotiation style, soft negotiation style, when a person is adopting, we say he's cooperative in nature. If he is adopting hard negotiation styles, we say he's competitive in nature. As far as a competitive negotiation style is concerned, a person will always think, I should win, he should lose. In cooperative negotiation type, he will say, I will bend a little, let him bend a little. I will go back a step, let him also go back a step. Maybe compromise also can enter into. But what I am requesting you to consider here is, if you are adopting the style of cooperative negotiation or hard negotiation, competitive negotiation, what will be its impact on the entire negotiation process may not be understood by you, but a mediator who is assisting in the negotiation will have to identify this. What are the characteristics of soft negotiation? When you are in a soft negotiation style, when you are adopting soft negotiation style, you consider the other party as a friend, not as your adversary. But whereas in competitive style, you consider the other person who is negotiating with you or with whom you are trying to negotiate as your adversary or opponent. That is the difference. In soft negotiation, your aim is at settlement. You are not bothered what the other person is going to get. But in competitive style, your aim is victory. Sometimes you also want to see to it that the other person loses, as in the case of those two dogs which did not want just to win, but also wanted to see the cats lose. In soft negotiation style, people give offers. They change their positions very easily. They disclose their bottom lines. And sometimes they go to an extent of trying to impress the other party by telling, look how much I am giving, I am ready to give so much, I am ready to give so much. They trust the process, they are flexible, and they are respectful to the other party. In competitive style of negotiation, what happens is their aim is to defeat the other person. And they don't disclose information at all. Sometimes they mislead, they give some false informations. They are bullying. Sometimes they may tell lies also. They're inflexible. They may be bluffing also. And they don't disclose their bottom line at all, or misguide and give some false information about the bottom line, so that mediator will not even be able to assist the other party to go near the negotiation table. That's where the fix comes. But one thing we need to understand here is, it is important for the mediator to understand whether the parties are adopting cooperative style or competitive style. You just understand, we need not have to feel bad about their decision, because it is their process, it is their problem. We have to understand that. In hard negotiation, why people are hard? Sometimes people are hard on themselves also because of the various situations of the past. We do not know the past of that individual. That's where we have to spend a lot of time in pre-negotiation stage to understand, why is this person so hard? Why is he taking such a hard decision? It's because something has happened in the past. We can't allow that person to live. We are all prisoners of the past. We can't allow a person to live away the past. Mediation is a process where we allow the party to speak about the past in the present, but have a reasonable expectation about the future. So past in the present, future in the present, that's what you have to prepare in pre-negotiation stage. I was telling you that the people are very hard. They are not just hard about the other person, they are hard on themselves also sometimes. And please understand, every individual will focus on his own interest, or even the advocates. who come to assist their party, they will be trying to safeguard the interest of the person whom they represent. That's where we have to understand that here is a hard person who has adopted hard negotiation styles, and when the person himself is very hard on himself, and added to that is adopting hard negotiation styles, what happens to the other person? He feels very uncomfortable. He feels threatened, and he feels it very difficult to talk to him, forget about conversation and going to fruitful discussion. It's at that level we have to intervene. Let us come to another scenario where the party is very soft, and is not just soft, he is adopting soft negotiation styles. Then what happens is, there is always an element of apprehension in the mind of the mediator which may come. If this person is so soft, maybe the other person may take advantage. This, we are not supposed to form any opinion based on the observable behaviors of individuals. That one aspect we need to understand. Why people do not adopt soft styles is because sometimes they use these styles as strategies. They use hard negotiation style as a strategy instead of soft negotiation style as a strategy, because they do not want the other person to take advantage of their disadvantageous position. Number one, they do not want the other person to think that this person is very submissive, very weak, and he can be my subordinate like. This impression they don't want to create. That's where even a cat on the mediation table wants to look like a lion. Cat is a cat. Cat knows that I am not a lion, but still cat projects itself as a lion. These things can be very carefully understood by the mediator. The mediator watches the body language, and if he is an expert in the communication skills, then he will understand he is a person fit for cooperative negotiation style, but not for competitive negotiation style, but he is adopting that competitive negotiation style. This you can make out. That's where your skill comes into picture. Now, what's our role here? We use a strategy in such a way that you're not afraid of the other counterpart. We see to it that both the parties are respectful to each other, and we encourage the parties to have strong commitment to whatever they want. They need not agree, but they have to agree on one. They need not have to agree on terms. They are at liberty to disagree, but they have to agree to disagree very gracefully. This is one element where we bring them. All these things should happen only in the pre-negotiation stage. It's always a myth to consider that in order to win in a negotiation, you have to be hard. And there is another myth. If you want the other party to love you, you should be very soft. Not necessary. As far as negotiation is concerned, these two aspects you can ignore. One aspect that I request all of you to consider here is that on the negotiation table, encourage parties to take strategic decisions, and sometimes you must be open to receive the participants exercising their tactical choices. You can't avoid. That's where we say, don't form any opinion at all. If they're projecting their tactical choices, you have to identify, oh, these are tactical choices. I'll keep it in this box. These are strategical choices. I will keep it in this box. Then you have to understand what will make each other to get into or buy into an agreement. That's where you have to fix all these things in the pre-negotiation stage. Now there is yet another negotiation style that is known as principled negotiation. As far as this principled negotiation is concerned, part of it comes in pre-negotiation stage, part of it we adopt in negotiation stage and post-negotiation stage. When we adopt principled negotiation, what happens is the process becomes very comfortable and acceptable also. When principled negotiation is adopted or encouraged between the parties, unknowingly they agree with each other. That is one miracle that can happen if you follow all the elements of principled negotiation. By and large, 7 elements are considered as very important elements of principled negotiation. One is interest. Understand the underlying interest of each of the parties. What is an interest? In mediation, we always come across 2 words, position and interest. Position is what I want. Interest is why I want what I want. Every dispute is the result of violated expectations. What I want is not happening, what I do not want is happening. What do you do then? Understand the underlying interest, find out why they do not want something to happen or why they want something to happen. This is the first element that we need to understand. Why am I using this want? Please understand, in the definition of negotiation, I requested all your counsel to see, negotiation is getting what you want at an acceptable price, not what you need. Needs can never be negotiated. Needs have to be accepted. No question of any negotiation on needs. Why do we negotiate on wants? Wants are always something in addition to need. If I have only this dress, this is my need. I already have 10. Now I am looking at another one. What is that? It's want. Something in addition to. That can be negotiated. Whether I should buy or not, at what price, whether I can give it up or even forget thinking about it. All these things can be negotiated because it's something in addition to need. Desires should never be entertained to be negotiated. So in principled negotiation, we do not entertain people to negotiate on needs or on desires. Indirectly, we handle the situation in such a way that we understand whether it's a want. If it is want, that can be negotiated. Now, the second element is legitimacy. Whether there is a quest for a fair deal is what we have to consider. If it's unfair, illegal, we should not entertain it all. This is principled negotiation. At the threshold itself, we should say, no, not possible. Not possible on my mediation table or any mediator's table. That's how we should be very strong because we are the ones who are controlling the process. Next is relationship. That's the third element. You need to understand the dynamics of relationship between the parties. You should always go to a stage which is a stage where the parties were before even the seed of dispute came into existence. This relationship dynamics, this element which is considered as one of the essential elements of principled negotiation, should be addressed, and lots of information has to be gathered in the information gathering session. What we say yesterday's Andrew's session was extremely informative and it is helpful. If you have left it, please go through that session. This session can be understood in a better way only if you have gone through Mr. Andrew's session. So in the information gathering stage, you have to understand all the dynamics of relationship between the parties. then the parties will demonstrate the trust in you, and they will demonstrate the trust in the mediation process. That's one thing. Now, next element is alternatives. Even if when the parties have agreed, A has told you, yes, I am agreeable for this. B has told you in another room, yes, I am also agreeable on that. Still, I would, as a mediator, never give up on these alternatives. Assuming for a while, you do not want to agree on this. Do you have any other better deals? If you have better deals, please consider those better deals. You are not compelled to agree on this. I repeat this as many times as possible. I tell them that you are not compelled to agree on this mediation table. Give them complete autonomy to think many a times not to agree and then agree, so that in post-negotiation stage, you are completely safe. This is one thing that you need to understand. And I encourage them to consider all their partners and the partners of the other side. What is the best alternative the other person has got? Then, this is the fourth one was alternatives. And the fifth one is options. I always encourage parties, if you are in principal negotiation, the moment an option comes, probably most of you know this Edward de Bono's 6-hat thinking method. So you have to apply that yellow hat thinking, value additions to the options that are generated on the negotiation table. Now, as far as these options are concerned, I always ask both the parties to check whether these options are workable and functional. And immediately they can fall back on these options. These are the three things you have to make them very clearly understand. Next is the commitment. I tell them, don't agree on what you cannot commit to. This commitment is very important because they have to stand up to what they are agreeing to. It is in this scenario, what we request them to consider here is, are you sure that you can commit yourself to this statement that you are making in this mediation settlement agreement? If they say, then that can be part of negotiation. Otherwise, the earlier ones, options, that definitely it goes out. Now, after all these 6 elements, there is yet another element that's called as communication. But this communication captures all other 6 elements. Communication, one thing that we have to understand is quality of negotiation is always directly proportionate to quality of your communication. It always depends on the quality of communication. Yesterday's Professor Andrew sir's communication session, you have to watch completely once again. We have to be very careful that parties should not feel that there is a threat from the mediator or the person who is assisting them in negotiation. That's one area where we have to be very careful about. Now, having learned about these 7 elements of principal negotiation, one thing that we have to understand is, how do we demonstrate these principles of elements of principal negotiation in our mediation process? Number 1, see to it that before negotiation starts, parties consider each of them as problem solvers for one another. Their mindset is, I am here because of the problem created by him. He says, I am here because of the problem created by this person. So, your endeavor would be to see to it that there is a problem. you want resolution of that problem or dispute resolution, both of you have to go hand in hand. Here is a problem solver for you. Here is a problem solver for you. Let us sit together and work. This is what you have to see in the pre-negotiation stage before you get them to in-negotiation stage, number one. Now, another thing that you do is separate the person from the problem. This is very difficult, but if you do not separate the person from the problem, the whole thing goes out of your hand. Not just you as a mediator. You should also encourage parties to look at the problem. In the pre-negotiation stage, they will tell he is like this, he is like this, he is like this, A to Z. They will tell every negative thing about the other person, how bad they are and how good they are. Now, I generally tell them, assuming for a while, the other person is an extremely good person. Would you have given everything to him and walked out? May not be. I don't put this way directly, but I make them understand. What would have been your call if the other person, if your brother were to be a very nice gentleman? What would you have done? Then they will understand that let us not talk about the person, but let us talk about the problem. So you direct them, direct their focus about the problem. But if you have not heard them speaking about the person, you can't do it in negotiation stage. Again, they will say, my brother did that on that day. So you erase all these options of those people talking about the person in the negotiation stage. Separate the person from the problem. Third, be soft on the persons, but hard on the issues. Encourage parties also when they are discussing or when they are in joint sessions or when they are talking to you, may not be the other person may not be there. But if they are using some harsh words, you tell them you can be soft on the person, but hard on issues. You can take your call. Nobody is forcing you to agree or disagree on anything, but let us be very soft on the other person. That's all we are expecting here. Be respectful to each other. That's how you bring the elements of principled negotiation. And again, focus on interests, not on positions. Why you want what you want? When you ask this question, many wants will go away. They have filed a petition case for 15 properties. Do you want this property? Why do you want this property? Why do you want this property? Can you help me understand? What's your interest in this property? Madam, I don't want 3, 7, 9, all those things, and only 5 out of 15 properties are there in which he wants partition. So focus on interest than on their position. But what is their position? Position is I want share in all the 15 properties. This is their position. So you are shifting their focus, mindset from position to interest. Why they want what they want. Every part of their wants, you have to talk. You don't think that this is not important, this is not important. What is important to them, let them decide. Next one, explore the interests. Many times, parties will not be knowing what exactly they want. I'll give you an example of a case where 2 brothers had filed a suit for partition against their sister. It was father's self-acquired property. In Indian law, if a father dies, all the Hindus, all the 3 children will get equal share, 1/3 share, 1/3 share, 1/3 share. The sister said, my father has executed a will in my favor, registered will in my favor. All the 11 properties should come to me. I am not going to give anything to my brothers. The brothers wanted 1/3 share. This lady was in abroad, coming on every date of hearing to the court. Even though her presence was not necessary, she would come. The father had written, father was a highly educated man, and the witnesses were also highly educated people. A father had written a will in his own handwriting. He had explained why he is giving all these properties to his daughter, because his daughter and son-in-law took him out of debts at one point of time. And all these 11 properties he acquired only because of the support given by his daughter and son-in-law. That's why he wanted all these 11 properties to go back to his daughter. And the sons were employed, well employed, gainfully employed, so he did not want to give anything. The sessions went on. The lady stuck to her position. She said, I want all the 11 properties. Then in the pre-negotiation stage, probably we had not put lots of quality time, invested lots of quality time is what the mediator thought. And again, a pre-negotiation stage was in a way created, and the lady was asked to speak. She said, I did this, my husband did this, my husband did this. Every time we were consulted. After my husband's death, after my father's death, we are neglected, we are ignored. We are neglected, we are ignored. Repeatedly, she said. So, what did actually she want? Then we asked her, help us understand, what is it that you are missing? I am missing that bonding from my brothers. I am missing that respect that they were giving me and my husband before my father died. I am missing all those things. How do you value that? I value that more than any of these properties. That's where, actually, that's what is meant by explore interest. What actually she wants. Many a times we will not be knowing what we want. That's where I tell, on the negotiation table, they start negotiation on with regard to some subject matter, but the subject matter also changes. The substance of negotiation also changes. The substance of negotiation here is something different. Need. Those of you who are interested in general reading, please read Maslow's hierarchy of needs. So Maslow's hierarchy of needs, one of the needs is love and belongingness. She was in need of that. She did not, you cannot negotiate, because I told you already that needs cannot be negotiated. It has to be satisfied. If that need were to be satisfied, she did not want any of these things. When this was again brought in the joint session, when I asked her what is more important to her, she said this, and the other party also understood. The matter got settled between the brothers on one side and sister on one side. Look at this. What is that we have brought? Element of principled negotiation. Explore the interests. Why is it very important for her? Why is that she is fighting this case? She said, I am missing that. In order to get that, she is fighting this. But the subject matter projected is 11 properties, but that is not actually the subject matter of negotiation at all. That's where we need to understand whether people are looking at tangible goals or intangible goals. In all relationships, by and large, money speaks. No doubt about it. But there are some negotiations where tangible goals will not satisfy one of the parties. That also we have to keep in mind. Now, another principled negotiation, element of principled negotiation is invent options for mutual gain. You have to invent options for mutual gain, and you have to use objective criteria. How do we use objective criteria? In a suit for partition of a small property, a suggestion came out, either I will buy the house or you let him buy the house, because we cannot cut the house into two parts as though it's a cake. Fair enough. He said one said the property can be valued at 50 lakhs, I will give 25 lakhs. The other said, no, it is 1 crore. Then how do you do that? I am not having 50 lakhs to be given to him, but let him give 50 lakhs to me, I will agree. But according to him, it is 25 lakhs. Whether it is the property is worth 1 crore or the property is worth 50 lakhs has to be decided between them. That's where we go for objective criteria. In one case, it so happened that the parties were alleging the question, raising the question of an example. Let us take it this way. Parties were alleging that the husband is impotent. An expert's opinion was taken. The doctor said, in this case, it is curable. Probably with another 5 or 6 months medication, he will be cured. Within 1 year, everything got resolved between the parties. So here we go for objective criteria, where we take the help of external experts or external agencies to decide what is best for both the parties to agree or disagree. This is another element of principled negotiation. Now, having said all these things, what are the skills that are required for a mediator to assist in negotiation? One is questioning skill. You must be very competent. I suggest that we should frame questions before asking the questions. And then we should also parallelly have 1 or 2 pages. I have 1 page, I fold it into 3 parts. Question: what if the desired answer is not got to this question? What should I next do? What should I next do? A, B, C. That's how you have to work. One skill is questioning skill. Another is empathy. Empathy is the foundation. It is the soul of mediation. So, of course, active listening is part of empathy. You have to understand the other person as that person wants to be understood. Empathy is understanding the other person as that person wants to be understood. If the mediator is empathic, it's not just enough. You should see to it that the other person with whom they are negotiating should also be empathic towards this person, and this person should also be empathic to other person. That's where mediator's understanding of empathy should be so profound that it is not just enough that mediator is empathic. We should create an environment. That's where the setting and atmosphere is one of the wonderful communication skills. Your mastery of the communication skills plays a vital role in bringing settlement on the mediation table. That empathic connection between the parties, one, it is brought in between them by setting a congenial atmosphere through the efforts of the mediator, miracles happen. And one is your questioning skills, another is empathy, and a third one is patience. Yesterday, Mr. Andrew was telling, I always keep one slip where I put shut up. That was very interesting. I generally write PAP. The moment I start any mediation, write PAP, patience always pays. P.A.P. So PAP I write. So even when I want to speak something, I withhold myself. Patience always pays. Pat, I say. So these are very important skills. Why do we need these skills? To know what they want. Many a times they do not know what they want. They don't know what their problem is. They don't know what is not their problem. They don't know what exactly is the problem of the other person. In order to assist the parties in understanding, in defining all these things, in making them understand the problem to which both should sit and find solutions together, you need to have these 3 specific skills. There is yet another thing that I request you to kindly consider. Sometimes they have many problems under the sun, and they are not agreeing on the negotiation table because of those ABCD problems. What makes them not to take a decision is because of several other problems also. That's where in pre-negotiation stage, we need to ask them whether do they have any problems other than the problem that's brought on the negotiation table. Because at the end of the day, after all our efforts are gone in, they will say, because of this, I can't take decision here. That's where our quality time in pre-negotiation stage and our skill set, use of skill set in negotiation stage. Quality time there. Use of skill set in negotiation stage is very important. Now, how do you help them? Do you know the boundaries with which you can settle? What is the least you can give? What is the maximum you can expect? What is the least the other person can give? What is the maximum the other person is expecting? So boundaries. Make them understand, make them know this is one aspect. How do you be an effective negotiator, or how do you assist them effectively in negotiation depends upon understanding this area of know-how is what we say. K-N-O-W, know how. Understand the role, understand the value of what you are offering to the other side. According to you, what is it that you are offering? What is the value of that? Oh, I am offering so much, madam. Fine. What do you think the other person's perspective is about the value of the offer that you are making? Oh, he doesn't value much. Then what will he value much that you can offer? Do you know? Can you try to understand on this? Can you help us understand? Can you get something more on the negotiation table if it is possible? So that's how we navigate. We navigate the process in such a way that they know what they should know. This is very important. And facts, figures, statistics, all these informations, you must see to it that they bring on the negotiation table so that there is always more information given to you so that you can assist in negotiation. There is difference between why on one side, what and how on another side. First, with our skill set, we have to understand what they want. If both parties agree on what they want, then you can help them to arrive at a settlement as far as how to reach that, how to get that to the satisfaction of both these parties. Unless you address on this what quarter in negotiation, you can't go to how quarter. That's where you should have different blocks separately in any negotiation. These principles are essentially common in all negotiations, be it family mediation or commercial mediation, whatever it is. Now, I'm trying to give some inputs on conclusions and agreements. As far as conclusion in negotiation is concerned, I would always ask them, whether do you feel it is better to close the deal as per the terms offered by the other side? Would you like to close the deal with the terms offered by the other side? Do you feel it better? Or would you like to walk away? You are not compelled. You can walk away not having a deal also. This is what will be my concluding statement. Is it better to strike a deal or not to strike a deal? Please think and get back. I'll give them lots of opportunity. There are two schools of thought. Some people say when they agree, you have to strike the iron hot when it is hot. But I generally do not do that. I tell them, look, now these offers are there. Whether you want to have a deal or not to have a deal, please think over and get back. I will give them sufficient time to think and get back. This is one thing. Now, as far as this agreement is concerned, after the conclusion, the agreement comes. In fact, those of you who are interested in reading, please read Russell's book on negotiation. She says very beautifully, Russell is a wonderful author. She says, there's a cardinal sin. What is that cardinal sin? Whether the negotiator would have been better without a deal. If the negotiator would have been a better person without a deal, then it is a cardinal sin to see to it that he enters into an agreement. That's where we must be very careful. If an agreement is forced on any party, I don't say that mediators force, but because of the circumstances, there may be so many other third parties also. We have to look at all these aspects. Who is forcing whom to enter into some agreements? Third party interests may be there. All these aspects will come into, particularly in commercial mediations, we come across these situations. High-stake property issues, high-stake commercial transactions, we come across these situations. If an agreement is forced on a person, what happens is fulfillment of post-negotiation objectives will be definitely hampered. It becomes very difficult for them to fulfill the obligations to which they have agreed to if the agreement is forced upon them. One thing is, if the mediator focuses only on common grounds, but not on the differences, not on what they do not want to happen, probably post-negotiation stage, that is in the agreement stage, we will be caught in a web. We can't come out. There will be no successful settlement on the mediation table. That's where making the parties enter into a settlement where there should not have been settlement at all causes more damage to our reputation, to their life, and to their problems also. The ramifications are completely, the ramifications are too much. That's where I request all the parties, all the mediators to consider that let us not force agreement on them. Let us give them sufficient time to agree or not agree also. Now, having said all these things, I think 5:10 I started. It is 1 minute more. I don't know, maybe I have taken 15 minutes more. I'm extremely sorry for that. I think I have covered all these 5 subtopics that are assigned in this training program. Thank you all for your patient listening.
Thank you, Susheela Madam, for your insightful discussion on the topic. Am I audible?
Yes, please.
Madam has given us a very insightful information, and she has said that quality of negotiation is always directly proportionate to communication. So the mediator has to learn communication skills first and then negotiate with the parties. And then she has stated that separate the person from the problem and talk to them extensively so that they can come out with the problem, and we have to differentiate between the need and between the acceptable solution to the problem. And then Madam has given us 7 points on which we have to go, and the mediation. And the first is that we have to frame questions. That is a very good guide for mediation, that beforehand, when we enter into negotiation, we have to frame questions, what we have to ask, and as well as the alternative questions. Then she said we have to be empathetic, and then we have to be patient. The madam's word PAP is really very impressive, and all of us must follow that. Thank you, madam, for such a good lecture on this topic. So now we have some questions. The first question was from Deborah Melanie. She has said, have you had experience of parties agreeing during the mediation and refusing to sign an agreement after the settlement? If you have, if so, how would you treat this problem?
In my experience, I should be, I would like to fairly concede that on 4 occasions it has happened. In Indian system, we don't have a statute as on this day as far as mediation is concerned. They sign the mediation settlement agreement here, and then they go back to the court. And in the court also, the judge will ask them, have you agreed? If they say yes, then only the agreement will be looked into by the judge. And then the judge will once again go through the terms of the settlement. If the judge finds that it is in accordance with, we have a rule, Order 23, Rule 3, then if it is in conformity with that, then only the judge will say, yes, it is accepted. And then a decree follows. In one case, it so happened that after the agreement is signed before me, they went there and they said they're not agreeable. It is their decision. Parties' right of self-determination, we don't do. But in another case, it so happened that there are 3 other cases where the parties agreed, and then it was time to sign the agreement. One party signs, the other party doesn't sign. There is an impasse. One case was an impasse situation, emotional impasse, which I had not addressed properly. So I had to do de novo mediation in that case, and then she agreed and then she signed. The rest 2 cases, they couldn't get settled. They went back to court. After 6 months, one case got settled with another mediator, and another case got settled after a year with another mediator. But I don't see anything wrong in that, because it is parties' right. Until they sign, it is not binding in our contest. Even if they sign and go back, if the statute permits them, then it's different. If the statute does not permit them, it is different.
So now, can we go to the second question? The second question is from Mohammad Wasiuddin Dadni. He has said how to handle and resolve the issue of apology from one party.
Pardon? I couldn't get it.
He has asked how to handle and resolve the issue of apology from one party.
See, apology is an act, but behind that apology, there is an emotion which is forgiveness. Forgiveness is the fragrance the violet sheds on the heels that have crushed it. So if it is not voluntary, we should not encourage it. If it is voluntarily coming in the joint session, when there is an empathic connection brought in between both the parties, we can encourage parties. For some injuries, for apology, there has to be an injury, either emotional injury or a physical injury. For some injuries, apology is an answer, is the only answer. For some injuries, apology is not an answer.
Now, ma'am, the third question is from Ms. Rita Gujral. She has asked, what is the difference between competitive mediation and cooperative mediation?
There is nothing known as competitive mediation and cooperative mediation. Mediation is mediation. Parties sometimes are competitive, sometimes are cooperative, sometimes they jump from one style to another style, that's all. Mediation is a process. It is as it is. It is just a table. Parties can adopt competitive style or cooperative style.
Thank you, ma'am. Now, ma'am, there is another question from Ms. Hema Sahu. She has asked, empathy is double-edged sword. How to decide to what extent mediator should go?
Empathy is
never a double-edged sword. And how to decide to what extent mediator should go?
I respectfully agree to disagree with Hema Madam Ji, because empathy is never a sword. In all relationships, we should try to build empathy. Without empathic connections, we cannot understand our spouse, our children, our neighbors, or anybody for that matter. Empathy is very, very essential in every relationship.
Okay, now, ma'am, another question now is from Mr. Jitendra Adkonkar. He asks, how does a mediator get a party to negotiating table who does not trust the other party at all?
That's where in the beginning itself, I said, why they want assisted negotiation, because they don't trust each other, or they don't like each other, or they love each other. In these 3 conditions, they cannot negotiate. When we love another person too much, we can't negotiate with that person. If we do not have trust in another person, we cannot. If we do not like, we cannot negotiate with that person. Under such circumstances, only the role of mediator to assist in negotiation comes. Then we will tell them, look, you do not, for your own reasons, you say that you do not have trust on the other person, but you have trust in the mediation process. You see if you can get whatever you want. then let us see. So I will first see to it that he gets enrolled in the process, and then slowly if he can develop trust in the other person, that's good.
Now, ma'am, sorry.
The process creates trust. The environment of trust is created by the process. So only thing that the mediator has to do is to enroll the parties to participate in mediation.
Yes, ma'am. Now one Miss Nishta Singhal has raised her hand and she's wanting to ask a question. Yes.
Thank you, ma'am. Ma'am, my question is that if we let the pre-negotiation stage go on too long, could that create this doubt in the fear of the doubt in the parties' minds that they are not heading towards an agreement, but they are opening the Pandora's box, and does the process start resembling counseling in a way? I'm new to mediation, so this is coming out of my imagination while you were explaining pre-negotiation stage. And I could understand the importance of taking that quality time.
Quality time, what is quality time is left to you. How much time you should prescribe and how you navigate the session is up to you. So how much of time, when I say quality time, it doesn't mean hundreds of hours or hundreds of days and hundreds of years. It can be 10 minutes also, it can be 10 hours also. But see to it that there's a focus, there's an attention, there's a direction, so that they explain everything about the past. How do they explain within the given time? It's up to you to navigate.
Right. Thank you, ma'am.
Okay, ma'am. Ma'am, the next question is from Dr. Kishore Dere. He has asked, who is a failed negotiator?
I don't say that the negotiator has failed. But if the parties do not agree, it is their problem. We can't say anything. But I would rather, if I were to be called as a failed negotiator, I would say if I ignore the elements of principled negotiation, then probably I'm not doing my duty as a negotiator, number one. Or if I'm invited to assist the parties in negotiation as a mediator, if I don't follow the principles of elements of principled negotiation, probably I will be failing in my duty as a negotiator.
Ma'am, now the next question is from Adenhir Jones. He's asking, interest, how does doing justice fit into the paradigm on negotiation at 3 stages?
What you have to do in negotiation stage, what you have to do in pre-negotiation stage and post-negotiation stage, you should have a clear idea. And you should have prepared notes for that. And you go in those areas knowing that I'm only entering this room, I'm not entering this room. That's where you must be very clear about your boundaries that you put. Only then you can assist the parties in negotiation effectively.
Ma'am, the next question is by Mr. Jitendra Adgonkar again. How does a mediator get a party out of zone wherein he thinks of damaging the other party in spite of getting what he wants?
The question is a wonderful question.
Yeah, should I repeat it, ma'am?
No, the question is a very wonderful question.
Yes, ma'am.
One thing we make very clear in every mediation, in every negotiation stage, is on this mediation table, what they can expect to happen, what they cannot expect to happen. So these are all statements that comes from the mediator as part of their ground rules only, as part of the session ground rules is what I say. Whenever I see something happening like this, we will make them very clear that you can expect something that you want to happen if the other person is agreeable. You cannot expect in mediation generally, not that I'm telling about you, but in general on the mediation table, one cannot expect something to happen which would damage the interests of the other party. I would make it very clear to them, if I see an element of this type of strategy stepping in somewhere.
Yes, ma'am. Ma'am, another question is from Miss Daksha wants to ask a question. She's raised her hand. If she can be, Miss Daksha. She's not been unmuted. So then there is another Miss Shashi Pathak. She has also raised her hand. She's asked a question. Rahul, can she be unmuted? First, please unmute Miss Daksha. Please unmute Miss Daksha, Rahul. So is there anybody else who's, there's no other question typed here. Next question is from Mr. Anand. He says, if one of the parties is not having 100% trust or confidence in the mediator, how to gain confidence of one party?
I wouldn't continue with mediation at all. If basic trust is not there, I wouldn't continue. If during the process of the mediation they lose trust in me, I would not continue. If they don't have anything against trust factor, trust issues as against me, then they can start. They may not have trust in me, but they don't have distrust. That's enough for me. But if they have an element of something against me as far as trust issues are concerned, I wouldn't go ahead with the mediation.
Yes, ma'am. The next question is from Mr. Kotalya Kukunur. He's asking, is it good that most of the arbitrators and mediators in India are retired judges, whereas in foreign countries, the mediators or arbitrators are trained for that purpose only?
Anybody who is trained in mediation will be a better person to assist in negotiation as far as the matters that are referred to a mediator to resolve a dispute. So I would say that whether you're a judge or any other professional, if a person is trained in mediation, that would be an added advantage.
Ma'am, the next question is how to handle a party when one party places the mediator in her shoes or position. Would you accept such a situation if you were in his position?
See, there is something known as who controls the process. Whenever a party tries to do what the mediator is trying to do, one thing is, if it is the controlling of the process, we tell them respectfully that as a mediator, it is only I who have the authority to control the process. This is one thing. Another thing is, there is something known as role reversal, the concept of role reversal in mediation. At times, parties ask us, what would you have done if you were to be in my position? They will ask this. Then we can also ask them, what, assuming for a while, today I am not the mediator and you are the mediator here and I am the party. Now you have come across all this that has happened in the last 15 sessions. Now you tell me, what would you do as a mediator? Help me understand, what would you do? This is permissible in mediation, excepting for controlling the process. The party can himself put himself on the mediation table, I mean, in the shoes of the mediator, and can tell something. We can't feel bad about it. At times they will tell, if I were to be like this, I would have told the other party to agree to this. He would tell, if I were to be a mediator, I would have asked him to take this offer, shut and go out. Then I will respectfully tell, maybe I don't do that.
Thank you, ma'am. Thank you so much for patiently answering all the questions raised by all participants. And before we end for the day today, I'll request all the participants to join tomorrow, that is 28th July. Our guest faculty would be tomorrow, Ms. Uma Ramanathan, mediation exponent, and she's a lawyer practicing Madras High Court. And the topic is ethics and ethical issues in mediation. So I request all of you to join tomorrow. And thank you again, ma'am. Thank you so much. And thank you, Santhanam sir, Rajiv Datta sir, Runeshwar Gupta sir, and Rakesh Khanna sir.
Ma'am, can I just take a minute?
Okay, so now you are unmuted. Okay.
Yes. Okay. Thank you for the opportunity. And I personally enjoyed listening to ma'am speak about the relation between mediation and counseling and psychology. As you mentioned, Maslow's hierarchy of needs. There's a very small question that how, as young people or young people who are interested in mediation as a career option, who are really passionate about mediation, can walk through this process. So please enlighten us with your suggestions. Thank you, ma'am.
You can identify some mediators who are doing private mediations and try to do shadow negotiation, and then get yourself associated with some mediation institutions. For example, Bangalore Mediation Center is there. There are other Delhi mediation centers are there. So you can just go and watch mediations over a period of time. When the statute on mediation comes, then probably you will get an opportunity. There will be a window, but do not stop learning is what I request.
Where are the recordings available?
Ma'am?
You will get all the recordings, don't worry.
Hello?
Please.
Thank you.
Ma'am, a very little question, last question I would like to ask. You told that just comfortable the parties and tell them that leave the past and come to present. So ma'am, if party is stubborn and they are not ready to leave the past, they want to live in past only. So what's the role of mediator in that stubborn situation?
First of all, we do not form an opinion on anybody that they are stubborn. Number one. Number two, I never ask any party to leave their past. I will only tell them that none of us can have control over the incidents of the past. We do not have any control over the incidents of the past. Probably reasonably, you can think of something happening in the future. Approximately 60 to 70%, you can plan about your future. Can we look at something that is going to happen than looking at something that has already happened over which we do not have control? This is how I would put it. I will not ask them to leave the past. It is very difficult to leave because I told you, we are all prisoners of the past.
Thank you very much, madam, for your time.
Thank you.
Thank you very much, ma'am. Very interesting. We've all learned a lot, and I think the topic, as you said very well, is something which is related to communication. That was yesterday, and I think you repeatedly said that anybody who's trying to be a good negotiator should also be a good communicator. I think we have learned a lot, and we have to just thank you for your patience and giving us this valuable time. Thank you so much.
Thank you very much. Thank you.